An initial meeting with a client can be as varied as the legal needs of that particular client. In the entertainment industry, a client may be referred to an attorney by another attorney who does not happen to work in entertainment, trademark, or copyright, or simply you can find an attorney on the internet by searching a website and learning more about them, or maybe through an attorney referral service. But after introductions and learning the purpose of the call, the very first thing an attorney should do is, when a prospective client calls the firm, is to clear any potential conflicts of interest. Attorneys have an ethical duty of undivided loyalty to only represent clients in which there is no conflict. An obvious conflict would be when the attorney represents, or has in the past represented, a music publisher and the prospective client is seeking legal advice regarding a songwriting contract with that particular music publisher. On the other hand, it's not a conflict if the attorney represents a songwriter in a deal with a certain publisher, and a few years later she represents another songwriter making a deal with that same publisher. Sometimes there are conflicts that can be waived by written agreement of the affected parties, and generally, for example, a new solo practitioner can clear a conflict quite quickly because she knows who she has represented in the past. But the longer a lawyer has been in practice, and if there are several attorneys in the firm, a conflict must be cleared with the whole firm before an attorney can proceed. The conflict check must be done before an attorney reviews any documents or learns any details about the prospective matter the client wants handled. At the initial contact with the attorney, be prepared to tell the attorney the names of every person involved who's on the other side of the deal with the client, whether that's a record label, a publicist, a distributor, a producer, whoever those parties are. If the other party is a small company or a business, then it's advisable to give the attorney the names of all of the principals of the company involved. At the initial meeting, whether in person or electronically, the attorney will want to know exactly what type of legal services are to be performed. If there's a contract or a deal point memo, for example, those documents should be given to the attorney. When a client gives me a contract to review, I typically ask the client to tell me what the deal is supposed to say and what it is the client wants to achieve by making the deal. I then make certain that the contract does what the client wants it to do. And of course, I advise the client what's in his best interest to vary the terms of the contract. Once the scope of the service is identified, the attorney is in a better position to advise the client the amount of the fee advance that may be required, the projected out-of-pocket costs, if any, what the total anticipated cost might be, and how long it will take to perform the services. An experienced entertainment attorney has a better handle on what things may cost rather than an attorney who's never handled a particular type of contract or matter before. Make sure to ask what the hourly rates are for each attorney involved, and the hourly rate should be spelled out in a written fee agreement, which also should identify the scope of the services and how payment is handled. The key is to ask questions. If it's the first time working with an attorney, sometimes the client will not know what questions to ask at the initial meeting, but the client must feel comfortable asking any question, whether it's the so-called dumb question or not. Lawyering is second nature to attorneys. It is not to the client, so it's important to have the type of relationship that the client's comfortable asking any questions. Another type of visit a client will have with an attorney is the shopping for an attorney conference. When clients are seeking general career advice or expect to have more than one single contact with an attorney, the prospective client may set up meetings with several attorneys in order to check them out, to shop, and to see which one fits best. Lawyers expect that clients will want to know something about their background and experience in a manner that is more personal than just simply reviewing a website. A person may have great credentials on their website, but at the same time, the client may not care for the attorney's personality. Clients also meet to gauge the attorney's availability. Is the attorney too busy to tend to the needs of the client? Are they in trial? Do they have too many other matters going on? But by the way, it's best to know in advance if there's a charge for the consultation, no matter what the purpose of the consultation is, whether it's the get to know you or for substantive advice. Oftentimes, an attorney who is not providing substantive legal advice will not charge for the get to know you meeting. However, some attorneys charge for the meeting because it is a use of the attorney's time when they could be billing other matters. The key to a successful initial meeting with an attorney is to be prepared to let the attorney know what the client needs done, find out what it will cost and how the services will be billed and paid, and to get answers to the questions that the client has.